This Honorable Court of Tennessee is now in session.
Good morning, everyone, and welcome to this call of the November docket for the Tennessee Court of Criminal Appeals in Jackson, Tennessee. Each side is given 20 minutes per side, and when we ask you to introduce yourself to the court, please tell us if you wish, the appellant, if they wish to reserve any time for rebuttal. The panel serving this court today, we go all the way across the state, Middle Tennessee. Judge Tim Easter from Franklin, from East Tennessee, Judge Homer McGee Ogle from Sevierville, and I'm John Everett Williams from the West in Huntington, Tennessee. Would like to always tell you how much we appreciate the staff, AOC and Judge Clerk Hivner staff for the preparations that have to be done before this, and to the attorneys, I thank you. The panel is very, very grateful that y'all are willing to meet this way. We look forward to returning back to the courtroom in January, and hopefully there will not be very many interruptions to it. We've all learned something through this process, and we do appreciate the efforts, extra special efforts that your staffs and your people have had to make this happen. With that in mind, let's call the next case.
State of Tennessee versus Quincy, Lamont, Collins.
Counselor, you ready?
Yes, Your Honor. Good morning, Your Honors. Todd Ridley on behalf of Mr. Collins. If I could have 3 minutes for rebuttal.
I'll keep up with it. Thank you.
Okay. There are three issues raised in the brief, and I think I'll start with the first and most important issue, and that is that the trial court erred by denying Mr. Collins's motion to suppress his pretrial statement to police. As part of that argument, we are arguing that both his statement to police and the handgun that was later recovered should have been suppressed, and that the lack of suppression caused him prejudice, and the result should be a new trial where those two items, or the statement and that item, are not available to the state for evidence. So the argument begins with Mr. Collins's assertion of his right to remain silent. But before I get into the assertion of the specific rights, I think some context is necessary for how the statement was made. So Mr. Collins had been arrested and had spent the night in jail, though he was not able to get any sleep. While he was in jail, he faced some threats from other members of the jail. And so he's going into this interrogation with that as background, with no sleep and threats of physical violence towards him. When he gets into the room, he asks about, or there's a brief discussion of his Miranda rights. Now, I'll concede that that was discussed. The detective did broach that issue. At that point, Mr. Collins said, I don't want to make a statement. The detective responded, I'm not asking you to make a statement. That's not what we're here to do today. Nevertheless, the form he handed him, the Miranda waiver form, explicitly says, I'm here to make a statement. So the point I'm making with that is that the detective's statements about what Miranda meant in this context and what the form actually said are completely different. And so that's the context in which Mr. Collins is speaking to the police. He's been misled after having been awake all night. There's being under arrest and facing these threats. So he's going into this not exactly in the clearest of mindsets. But one thing is clear. At 15 minutes into the interrogation, he says, I don't want to talk about this anymore. That is an unequivocal invocation of his right to remain silent. At that point, the interrogation should have ended. That's not what happened. Interrogation not only did not end there, the detective immediately followed up that statement by saying, who shot her? Who shot the victim in this case, is what he meant. So that is the first error. When Mr. Collins said, I don't want to talk about this anymore, the interrogation should have ended. Now, the state's response to that argument is interesting. Their primary argument appears to be that, well, in the recording, it doesn't seem like Mr. Collins said, I don't want to talk about this anymore. It says, he said, I don't want to talk about that anymore. Now, one, I'm not sure that there's a meaningful difference between those two things when it comes to whether he invoked his right to remain silent. But first, I just watched the video again, and I'll be the first to admit he has a fairly thick West Tennessee accent, and it's a little bit difficult to see if he's saying this or that, but it certainly sounded like this to me. Obviously, the court can review the recording and make its own determination about what exactly he said, so there's no real point in arguing about what's on the recording. But regardless, whether it's this or that, the meaning is clear. He invoked his right to remain silent, and at that point, the interrogation should have ended. And if there was any confusion about it, if the detective had been confused about, oh, I'm not sure if you're invoking your right about this one specific thing or in general, then the next question should have been, can you clarify for me what you mean by that? It should not have been, who shot her, which is what he asked instead. So the point is, 15 minutes into this interrogation, Mr. Collins invoked his right to remain silent, and the interrogation should have ended then and there. Anything that comes after that should have been suppressed.
Mr. Ridley, did your client ever sign the Miranda waiver?
Yes, I believe he did. And that is what the record shows, is that this written waiver was given to him. My point about it is that the contents of that waiver was the opposite of what he was told by the detective. So you have somebody coming into an interrogation room, having spent the night in jail, not gotten any sleep, and then he's getting two different messages. He's getting one message from the detective about what they're here to do, which is not to make a statement. And then he's signing a waiver that's far broader than what he's been told verbally by the detective. And if anything else, or whatever else that is, it's very confusing to the person who's the subject of that interrogation, and that's Mr. Collins.
So after he signs the Miranda, I'm assuming the officer said something, and then he says, I don't want to talk about that. So does it really matter whether he signed the Miranda, the form, if he later says, I don't want to talk about that?
I don't think it really does. I think once he can waive his rights and then re-invoke them, I think that's absolutely correct. And so once he gets back to, I don't want to talk about this anymore, I don't think it functionally makes a difference that he at one point said he would talk about it. But I guess I'm just kind of putting that in there for the context of how this came to be. And also just to admit, will be the first to admit that this did start off with a waiver, but the point for constitutional concerns, though, is that once he invoked his right, it does not matter that he had previously signed a waiver, because the invocation of the right is what matters.
I think you're absolutely right about that. If he's clearly says, we're done, I'm not saying anything else. But it seems to me what I'm seeing in your briefs anyway is he kind of went back and forth, and maybe yes, maybe no, and then just kind of volunteered some things without even being questioned, which I think under the law equates to being ambiguous. Would you not agree with that?
I guess I would agree to some extent with the invocation of his right to counsel. There is a little more give and take there. But I think when he says, I don't want to talk about this anymore, and I again will stress, I just watched the video and I think that's what he said, is I don't want to talk about this anymore. The next question, if there was going to be a next question at all, should have been about whether he was going to be willing to keep talking. The next question he got, though, was a detective asking him, who shot this person? So did he do what Your Honor just laid out as, I'm not going to talk about this anymore, and then cross his arms and then not open his mouth anymore? No, he didn't. He continued to ask about some things that were basically not unrelated to the case and more or less about his physical safety at the jail. And that kind of bled back into some questioning by the detective about the case in general. But the point is, when he says, I don't want to talk about this anymore, the interrogation should have ended. The interrogation, at least about the subject that they were talking about. If they're going to continue to talk about his safety, that's one thing. But to continue asking, who shot this person. That has nothing to do with his physical safety, and it's just a continuation of an interrogation designed to get a confession.
So you're
And-
basically saying he continued talking, attempting to elicit a response from the defendant?
He absolutely did. That was the sole purpose of the detective staying in the room, was to get Mr. Collins to say something incriminating. And I don't think there's any other, I mean, I think the detective would fully admit that he kept talking in the hopes that Mr. Collins would keep talking. And that turned out to be a successful interrogation tactic, as it frequently does. But if it's done as a tactic after somebody's invoked their right to remain silent, it violates the Constitution, and the results of the whatever comes in the subsequent interrogation have to be suppressed. So that is the highlight of the right, or the invocation of the right to remain silent component of the argument. But there's another component, and this one I'll concede to some degree that there were some equivocations on at least some of his statements, but Mr. Collins repeatedly throughout this interrogation referenced his right to an attorney. On a few occasions, it was in the "I think I need an attorney" vein, but on another occasion, it's "I need a lawyer." And those invocations of his right to an attorney should have ended the interrogation. They did not. The detective continued to ask questions and continued to attempt to get Mr. Collins to make statements to the police, make statements or incriminating statements without the presence of an attorney. And that is where the violation happens. Though there is some, then the state points them out, and I'll concede that at least a couple of those statements are somewhat equivocal, and somewhat equivocal statements of a need for an attorney are things that the court has in the past condoned. The statements where he's saying "I need a lawyer" are not equivocal, and especially when coupled with his prior statements of "I don't want to talk about this anymore." Just the general theme throughout everything he says before he says anything incriminating is "I don't want to talk about this" and "I need a lawyer." And anything he's really saying that is about that he's continuing to say to the detective is about his ongoing fear about going back to the jail and his need for safety. He's not saying anything about the case. But what the detective's doing instead is basically ignoring the parts where he says, "I don't want to talk about this" and "I need a lawyer," and getting him to continue to talk in the hopes that it will lead to an incriminating statement. But what should have happened is that the interrogation should have ended. And if the interrogation ends, they don't get these incriminating statements, they don't get the handgun, and the trial is likely different. So I guess that brings us to the last point about this was extremely prejudicial. Without these statements, the state likely does not get a conviction. Without these statements, what the state is left with is the statements of the alleged victim, and those statements are wildly inconsistent. And when you have a case that winds up being about a bunch of different things, and mainly is about the credibility of that witness, then these statements from Mr. Collins mattered a great deal. The presence of the gun mattered a great deal. And so without those, does the state get a conviction? Maybe, maybe not, but that's something that can be decided on retrial. So the state's claim now that this was all harmless, that it didn't really matter, didn't really have an effect. Well, it certainly seemed to the DAs who were trying the case, because they relied on this heavily in their closing, and it was the theme that led them to a conviction. Now, if they go back and try again, they can try without this and get a conviction that way. Maybe, maybe not. But it certainly is not harmless that it was presented in the first instance. Since I have some time, I'll talk briefly about the second two issues. Those are, I would say, less important, but certainly a part of what we're arguing today. The first one is that the trial court erroneously gave a flight instruction. Here, and this has been an argument that's been made several times in the past, is what we have is proof. The elements of flight are essentially twofold. First, there has to be a leaving the scene, And second, there has to be a hiding out or evading of arrest. It's undisputed in this case that he did leave the scene. But the hiding out part, the state put on nothing to show that. What they can show is that there was an arrest warrant issued and he voluntarily surrendered himself later that day. That's it. That's not evidence of a subsequent hiding out. And without that second element, the state is not entitled to a flight instruction. And
Didn't he leave the county and go to a couple counties over? He went to Humboldt, didn't he, from Jackson?
he did do that, but there's no evidence that that was an evading of arrest or hiding out. And
Wasn't there some evidence that he thought he had killed this lady? And that was the reason he left and went to another county? And actually, I mean, you say he turned himself in that day. The arrest warrant wasn't issued until a couple days after the killing, or excuse me, the attempted killing, correct?
Well, certainly that's when the arrest warrant was issued, but I mean, there's no obligation to voluntarily turn yourself into the police just because. When the arrest warrant issues is when his obligation to do anything is triggered. So I'm not sure that him leaving the county says anything in particular about hiding out or attempting to evade detection. It just shows he left the county or he left the scene where the incident occurred. But that in and of itself is not the same as actively avoiding detection, which is traditionally what flight or that second element of flight is meant to capture. So the important thing, though, is if they had issued an arrest warrant and they still couldn't find him, then okay, that might warrant a flight instruction. But when he turns himself right away, all that's happened so far is that a presumptively innocent person has continued to move about the state. That's not the same as evading detection or hiding out. And so once he turns himself in voluntarily and without any real dispute, I think that means that a flight instruction is not warranted under those circumstances. And again, this is one of those things where this mattered. And we know it mattered for the jury because the DA thought it mattered. The DA in its closing explicitly referenced this in order to get a conviction. So this isn't some just meaningless bit of boilerplate at the end of the jury instructions. This is something that the state thought was essential to it getting a conviction. And so if it was erroneously given, then it caused prejudice and requires reversal. Again, since I have some time, I'll mention the final issue, which is just the aggravated assault and attempted killing should have been merged. The state's argument on that appears to be that this is not plain error. I would just point this case to a number, or point the court to a number of cases where this court has found that that is plain error and has frequently done so after the state has even conceded it. So
How many since Watkins?
how many, I'm sorry.
How many cases has this court done that since Watkins?
That's a fair question. I'm not sure about that. I know I had one within the past 6 months, State v. Angela Kilgore. There was an assault conviction that merged with a murder conviction. And it was raised for the first time on appeal, and it was conceded by the state, and the court found that merger was appropriate. So on that specific question, I guess I don't know the answer to that, but I do know that it has happened within the past year, at least once.
I think it was a little bit anticipated that these issues might come up when the change was made after Watkins, because of some very specific language in Blockberger. So that's why I was asking that question.
I understand, and I'm sorry, I don't have a better answer. I guess I'm just going off memory from recent cases where I know it has happened, but I can't give you a number on how many times. I apologize for that. And if this winds up needs to be an issue for supplemental briefing, I'm certainly happy to do it. Just let me know. But that again is a relatively minor issue, as it doesn't affect the overall sentence. It's just something that we'd like the court to look at. But what we'd really like the court to look at is the two earlier issues, and most importantly, the suppression of, or the lack of suppression of his pretrial statement, and the gun that was discovered as a direct result of that statement. If there are no further questions about that, I'll save the remainder of my time for rebuttal.
Thank you. Yes, ma'am. General, you may proceed.
May it please the court, Catherine Decker representing the state of Tennessee. I'm just going to very briefly address the merger issue and get that out of the way because that is what defense counsel has ended with. First of all, I know of no case since Watkins where any court has held that attempted first-degree murder and aggravated assault were under Blockberger viewed to be the same and merged. So I may look at the Kilgore case, and if in fact that's what it held, I would be happy to try to distinguish that in supplemental briefing. But the way Mr. Ridley had described it, it's murder and not attempted murder, and that might be the difference. But in any case, Mr. Ridley has mentioned today and in the reply brief that the state conceded this issue. The state conceded this issue in 2010 before Watkins was decided in 2012. The state has not conceded this issue under the current state of the law. When the state drafted its brief in 2010, Watkins had not yet been decided. We're in a different state of the law. The state does not rely solely on waiver. In its brief on that third issue, the state analyzed this issue under Blockberger and finds, just as actually the cases that Mr. Ridley cites in his brief state under Blockberger, these are two different offenses. So
The way you allege the aggravated assault in this case in count 2 is bodily injury with a weapon for aggravated assault. Under Blockberger, aren't those the same elements that are alleged for the attempted first-degree murder in count 1?
well, in attempted murder, you don't actually have to have
But the way it's
It is.
alleged in the indictment indicates unlawfully, intentionally, with premeditation, attempt to kill the victim by taking the following substantial steps: shooting the victim and said victim suffering serious bodily injury.
But you look at how you look at the broad elements and not exactly the facts that are going to be derived at trial. And so for an attempt does not actually require bodily injury, and that's a distinction.
The way you pled it, it does. In fact, it requires serious bodily injury. Is that the distinction that you're?
The distinction is just that simply the definition of attempt does not require actual bodily injury. But I'd like, if I may, to return to now discuss to the first issue. And the trial court properly denied the defendant's motion to submit his police statement because the defendant did not unambiguously and unequivocally invoke either his right to remain silent or his right to counsel. So concerning the right to remain silent, and to refresh, this is what the defendant stated about 15 minutes into the police interview: I don't want to talk about that no more, whether it's this or that. I encourage this court to review the video. The defendant is very hard to understand, and I have listened to it multiple times. I have slowed it down and repeated, and I think that's what it takes to really understand what the defendant has said. But I'll just encourage the court to do that. And I've listened to that multiple times, and it says that. But even if he said, I don't want to talk about this no more, that was not an unambiguous and unequivocal invocation of his right to cease speaking altogether. And
Well, I agree with that. That I don't think the defendant has necessarily argued that didn't want to speak, but shouldn't it at least put the officer on notice that he may need to go another line of questioning and
well, Your
instead
Honor,
and find out what he really meant by I don't want to talk about this or that anymore?
no, Your Honor, under the Long case, when the statement is ambiguous or equivocal, the officer has no obligation to seek clarification. And in this court's recent Lalone opinion, the court noted that the language of a statement itself indicates simply that the suspect has finished his colloquy of events as opposed to wish to cease speaking altogether. And when the statements indicate only that the suspect desires to avoid answering particular questions or to avoid speaking about a particular theme, that is not an invocation of his right to remain silent in general. And that's exactly what happened here. So if
Okay.
you listen
Well,
to the
Can I ask you if the defendant said, I don't answer questions? Is that an unequivocal upholding his right to remain silent? I don't answer questions.
I don't, possibly that's not what happened here.
I know that's not what happened here. I'm asking, do you consider that an unequivocal response? I don't answer questions.
I don't want to answer any of your questions.
No, I didn't say that. I don't answer questions.
I'd have to see.
You want to ask me more? Why? I just told you I don't answer questions. Is that not enough?
Your Honor, I'd have to look at the context and see whether when he made that statement, he was, let me go on to tell you why that is not what happened here. Because if you look at the video, what happened here.
What if he said, I don't want to answer questions? Would that not be enough?
Your Honor, I think it's important to look at what the defendant's words in this exact case and how it fits into the context of the whole interview. And what happened here is this. Right before he made that statement, Sergeant Donald told the defendant that the victim had come into the police department 3 days before the shooting and reported that the defendant had threatened to shoot her. And when the defendant heard that, he seemed to get visibly upset, and he started to mimic the conversation that he and the victim had 3 days beforehand. And so he's using her voice and his voice and going back and forth to mimic, to replay that conversation. And it's after he does that, where he's visibly upset about the fact that she would have reported that conversation to the police, he says, I don't want to talk about that anymore. And it's very clear when you hear him say that in the context that he's not referring, that it's very clear that he's referring to that subject. He does not want to talk about anymore about the fact that that victim he considered to be a wrongly interpreted their previous conversation and reported that to the police as him saying he would shoot her. It's that very narrow and limited subject that he is saying he doesn't want to talk about anymore. And as this court has said in Lalone, a defendant can indicate that he does not want to talk about a limited question or a limited subject, and that does not constitute an invocation of his right to remain silent, period. He wants to remain silent on that particular topic. And that is what happened here. I'd like to move on to the right to counsel. It's important to look at each instance that the defendant raises, because this is not about a general theme or about how many references to counsel that the defendant made, because multiple ambiguous or equivocal invocations do not equal one unequivocal or unambiguous statement. You have to look at each individual statement and ask whether it is an unequivocal and unambiguous invocation of the right. And there is no statement that was unambiguous and unequivocal. So
Well, if I look at the officer and said, at any time during the questioning, I looked at the officer and said, "Officer, I think I want a lawyer to represent me in this matter before I continue talking." Is that an unequivocal request for a lawyer?
well, I think using the word "I think" might have made it not just, I don't know if the word "I think." I have,
I want a lawyer to represent me.
if it's clear that he wants a lawyer to represent him, if that's made clear in an unequivocal and unambiguous manner, yes. But it's important to look at exactly what the defendant said. And so the defendant in his brief concedes, he raises he pinpoints 5 points where he claims he invoked his right to counsel. The first and the fifth he concedes were somewhat equivocal. So I'm not going to touch on those because I think he's conceded that they were equivocal. So just turning to the second and third, which he lumps together. This is what the defendant says. "I need a lawyer. I ain't going to show you, well, I'm not going to show you no remorse. I need a lawyer then is what it sounds like." And then he goes on to say, "I ain't no dummy either, keep talking to you. So I just going to ask you, what are you fixing to charge me with?" So about that, there are 2 points. The first is when he says, "I need a lawyer," I think I need a lawyer is what it sounds like. This the kind of statement that courts have said is not an unequivocal or unambiguous invocation of the right to a lawyer. He is merely saying it sounds like I need a lawyer. But more than that, the United States Supreme Court in Edwards have made clear that when a defendant re-engages, when it's the defendant who continues the conversation, he has indicated that he is not invoked, that he wants to continue without counsel. And that's exactly what happened in this case. It was the defendant who continued without one word from Sergeant Donald to say, "I'm just asking you, what is you fixing to charge me with?" And then right after Sergeant Donald answers that question, it is the defendant who continues the conversation by asking another question, what he would get out of that charge. So it is the defendant himself that that reinitiated the exchange. And for that reason, under Edwards, this was not an unequivocal and unambiguous invocation of his right to remain silent. Let me move on to the next statement that the defendant highlights. Now, the defendant says that at some point, defense counsel says at some point the defendant makes this statement: "We through with this. I got to find out about a lawyer." And that, of course, certainly sounds like an unequivocal statement. But the problem is that is not what the defendant said. And here's where I particularly urge this court to look at the video, because the defendant did not make the declaratory statement, "We through with this. I got to find out about a lawyer." Those words appear in what he said, but they were a question. They were inside of a question. And here's what
did he stand up when he said that?
I'm sorry, I don't recall.
Did he stand up? I seem to remember at some point during these conversations, he stood up and said something to that effect, "I'm through."
I'm sorry, I don't recall, and I don't recall that, I don't recall. I know he stood up towards the very end and was asked to sit down. I'm sorry, I just don't recall offhand, but what he actually said was this: okay, I do want to ask you all, before we are we through with this? Because y'all are lying and I gotta find out about a lawyer. He said, are we through with this? He did not say we through with this. It's clear from that context that he's just asking, when will they be through with this statement? Because after they're through with this conversation, he will find out about a lawyer.
Well, that's exactly what I have written in mind. Did you think the defendant misrepresented that?
I would say that what the defendant represents as a declaratory statement is not what is seen in the video.
Okay.
It is, that statement is part of the question, are we through with this?
Yes, that's the way I read it as well.
I think that with those discussions of those particular instances, in addition to the fact that the defense had conceded that two of the instances are equivocal, I think that there's no statement that the defendant has made that is an unequivocal and unambiguous invocation of his right to counsel. And let me though go on to address the harm analysis and because on the merits, I think this court has to affirm the denial of the motion to suppress simply because there was no unequivocal and unambiguous invocation of a right to remain silent or to counsel. But let me discuss the waiver argument that the defendant has raised. And he says that if without the statement and the gun, and I'm going to rely on my brief for the fact that he has waived by never mentioning in his motion to suppress, the motion to suppress hearing, the order, there was no mention ever of a desire to suppress the gun. And of course, if he had raised the issue of the gun, the state would have been alerted to the separate legal analysis of inevitable discovery and discovery by routine investigation that applies to a motion to suppress a physical object. And we were never alerted to that. And so he has waived that. But in any case, let me switch to harm because it applies to both the statement and the gun. So the defendant represents that without the gun and the statement, the state would likely does not get a conviction because the victim's testimony was what he says was wildly inconsistent. So I'll tell you, I'll start with what she actually testified to. She gave detailed, credible evidence about everything that happened that night from the defendant entering her apartment to where he stood when he shot her, to what he did or did not say, to how many times she was shot, to the fact that she saw him take her things, waited until he left the apartment to leave detailed, credible evidence about his actions and her actions the night that she was shot. Her testimony is corroborated by the fact that 3 days before he shot her, she reported that he threatened to shoot her. Furthermore, after she was shot, she ran to her neighbor's apartment and there told her neighbor, "My boyfriend shot me." And that statement, by the way, came in as an excited utterance, which came in because the law deems that statement by the neighbor as inherently reliable. Furthermore, when the police arrived at the neighbor's house, the victim told the police, "He shot me." There's nothing incredible about that testimony. This was a victim who was shot by her boyfriend 3 days after he threatened to shoot her and testified about it. Now, what the defendant has labeled as wildly inconsistent are this. The victim testified at one point that she and the defendant broke up 1 week before the shooting. And another point, she said they broke up 2 weeks before the shooting. The victim testified at one point that the defendant knocked on her door. Another time she used the word, "He beat on my door." It's just inconceivable that with those trivial discrepancies between a preliminary hearing and the trial, that a jury would have completely disregarded her testimony that the defendant shot her. Also, the defendant claims that there was inconsistent testimony about whether she lived with the defendant at the address where he ended up shooting her. And in fact, the defendant has just misread that testimony because she said he hadn't lived with me there, but we lived together at 2 other addresses. So that's not even any inconsistency. And finally, as the victim lay in bed in the hospital with these massive rooms, and I've just outlined all the injuries and permanent injuries, horrible injuries that she had, she mistook grafts and scars from the surgery for wounds. And so she was confused at one point as to how many times he shot her. Again, the jury's not going to take that as a wildly inconsistent testimony that would infringe on her credibility. She was a wholly credible.
Is your reasoning for arguing this is in case we find the statement should have been suppressed, that it was harmless?
Correct, Your Honor.
Is that the reason you're making these points?
That is the reason I'm making the points. And,
Okay.
and to respond to defense counsel's argument today that that state could not have obtained a conviction without the statement and the gun. And of course, they absolutely can obtain a conviction when the victim herself comes in with credible testimony about being shot 3 days after being threatened by her boyfriend, and with an excited utterance coming in to corroborate, and with the police officers corroborating testimony as well.
Sufficiency was not raised as an issue, as I recall. It's just the suppression of the statement. So if we find the statement should have been suppressed, it was error not to, then this argument is being made to support it was a harmless mistake.
Yes, sir. Deficiency was not raised, and this argument is raised.
Okay. Thank you.
With I don't know if I have remaining time.
You don't, but we've always been lenient. If you need to continue, please.
I can read it. The remaining issues light, and I can certainly rely on my brief for that, because there was ample evidence for the jury to infer that the defendant was hiding out after he fled the town where the shooting occurred, thinking that he had killed somebody, hid in the woods. The ample evidence for that. And then, as this court has repeatedly found, because of the kind of benign nature of the flight instruction itself and compelling evidence of guilt, any error in providing the flight instruction would have been harmless. So I'll just rely on my brief for the details of that argument.
Thank you, General. You limited yourself to 3 minutes. Mr. Ridley, you got it.
Okay, I'll be very quick. So turning back to the pretrial statement, the state said multiple times that what happened was very clear. Now, at the same time, it says it was ambiguous whether it was this, whether it was that, what exactly he meant when he said, "I don't want to talk about this anymore." And so it's a bit contradictory for the state on one hand to say it's very clear that he didn't invoke it, and at the same time saying, well, actually, I've listened to the recording and I didn't really understand what was being said. So what was clear was that this is a man who has spent the night in jail, has not gotten any sleep, is under threats of violence, and who says to a police officer, "I don't want to talk about this, whether it's this or that. I don't want to talk about it anymore." That is as unequivocal as we can get, whether he invoked his right to remain silent. So the last thing I'll talk about is the prejudicial, or whether this was harmful. I'll agree that some minor quibbles about how the victim or the alleged victim testified in the preliminary hearing versus how she ended up testifying at trial is not the important part. What is important, though, is this is a charge of attempted first-degree murder. If you only have one person's testimony about this, and that testimony, whether it's contradictory or whether it's murky or unclear just as a result of not having a very good memory of it, that's not very much compared to having the fruits of an unlawful interrogation and the physical evidence that that led to. So when the state does its closing argument and it talks in detail about what was said to the police officer, it makes clear that the state was relying on this heavily to get a conviction, especially when we're talking about a conviction for attempted first-degree murder. I don't think there would have been any meaningful dispute about whether there had been a shooting without the interrogation and without the gun. There would just have been a question of intent, which is what the trial was about. So the details of her testimony is very important when it comes to showing that this was a premeditated act. What we have is, we know they spent the night together. We know, and this was days after this alleged threat, that she let him in to spend the night together, and that there's some kind of dispute between these two that leads to a shooting. We don't know the details of that other than through her testimony. The thing that elevates this from a shooting that might be an attempted voluntary manslaughter or attempted second, the thing that elevates it is his pretrial statement to police coupled with the gun that they recovered. So what the point of
What about the prior declaration or the prior threat and shooting an unarmed person? Those two things don't matter?
both of those things do matter, but both of those things are coming in.
Well, you said that was the only thing that they had was what you were talking to, this statement. And doesn't she have you on the gun? You never mentioned anything about the gun. There's no evidence about the gun, even asking for it to be suppressed. How did this get in?
Oh, okay. On the waiver argument, I will agree that the motion to suppress does not explicitly reference the gun. My point would be that the state's argument is elevating form over substance. What we have is a motion to suppress a statement, and the only way they get to that gun is through that statement. That if you look at the
we have no evidence of that whatsoever, Mr. Ridley, none whatsoever, and the state would be able to rebut that if they could. You just didn't raise it, and I think you're out on that. Let's be honest with you.
Okay, I mean, I will concede. It's the gun's not mentioned in the motion. It wasn't mentioned at the motion hearing, and it certainly wasn't mentioned at the motion for new trial. The reason I raise it is because it certainly was something that came in as a result of the statement And if you look at the arguments for the gun and the pretrial statement, they're identical. If this was a mistake in not mentioning it more explicitly in the motion for the suppress, then it was a mistake. But the arguments are the same. So if the court accepts one argument, it's really accepting the other, and it was just a mistake to not be more explicit about it below. But again, I'll agree with the state and with Your Honor that it's not there. So there's no point in me saying it was there, but I think it was implicit that both the statement and the gun were included in the same motion. Otherwise, there really wouldn't have been a point.
Thank you.
But otherwise, I think I've responded to the points I wanted to respond to. So we'll ask the court to reverse for the reasons that have been discussed. And thank you for your time.
Thank both of y'all. It's only a compliment to lawyers that we allow additional time sometimes. Well, y'all doing a good job. I don't want to cut you off. I learn something from you every day. And if you were from going to the same issue 3 or 4 times, believe you me, I wouldn't have any trouble calling time on you. But some of these things just take a little more time to listen to than others. And thank you. And we try our best to give as much leeway to the state as we do the defendants in these cases. And thank you, General, and thank you, Mr. Ridley, for your presentation today. We'll stand in recess till 1 o'clock. Is that correct?
Thank you, Your Honors.
This Honorable Court of Tennessee is now in recess.